In this topic, we'll recall employee rights in labor laws. On the PHR exam program overview chart, we'll be covering employment legislation, which is highlighted in red. It's appropriately located just below all of the functional areas and represents the foundation from which HR professionals will rely on to hone their craft and stay compliant. Every HR role has a layer of compliance, and the knowledge of legislation and experience in handling issues will help to minimize the business's exposure to legal risk. Depending on the path that you have chosen to take these courses, you may have already covered some legislative topics or just digging in. Either way, you are here just when you are meant to be, and will take this in stride. The legislations are categorized to make them digestible and relatable. You'll definitely want to be taking notes and, in addition, capture on the sidebar how each topic could be applied to solve problems that you've come across or aware of in news stories to quickly make the connection. Exam candidates are responsible for knowing the HR laws and regulations that are in effect at the time of their exam, which is based on January 1st, 2018. In addition, laws prior to 1960 will not be explicitly covered, though the concepts may be inferred. Let's take a look. We'll be covering the highlights, why this topic is important to HR, and the sources, the different ways legislation will come into effect. Human Resources, or HR, is conducted with a high degree of oversight from regulatory agencies through labor laws and legislation. An element of compliance for many labor laws is that written policies are in place. These are most often formally communicated through an employee handbook and outlines employee and employer rights and responsibilities. Labor laws also place heavy emphasis on documentation and record keeping. These include requirements for storage, retention, and disposal of all related records to employment. Sources of law are the origins of the law, the binding rules that enable governance. The term source of law may sometimes refer to the sovereign or the seat of power from which the law derives its validity. Here are the sources for employment legislation. United States Constitution. This is a supreme law and is a source of all government powers. Statutes. They are written enactments or authorizations made by legislature and expressed in a formal written document to pass law. Case law is also known as judicial precedents or judge-made law, and is the body of law derived from judicial decisions of the court and similar tribunals. Agency regulations. Agencies authorized to develop rules, criteria for measuring whether employers are in compliance. Agency orders. The powers of the agency to force compliance with federal laws. Executive orders. These are issued by the President of the United States. These bodies provide the core laws or rules of conduct established to maintain stability and justice that are applicable in all stages of an employee's life cycle, from pre-hiring process through termination. The Constitution. It serves to protect individual liberties and define how government is organized and the power and responsibilities. The Constitution is a blueprint for the entire government, and everything that the government does must be consistent with the Constitution. Therefore, if any action is taken by any part of the government that is inconsistent with the Constitution, that action is said to be unconstitutional, and it must be struck down. Statutes. These are created by the federal, state, and local legislatures, which are comprised of elected officials who have the power to create laws. Courts must apply statutes, if available, to the facts of a case. If no statutes exist, the court defers to common law or case law. Statutes are passed by legislatures who are empowered to make laws. Statutes have control over common law or case law where the two conflict. An exception to this is if the statute can be thrown out of court under interpretations made by the applicable case law that the statute is unconstitutional. Case law. Legislatures cannot write laws for every possible factual scenario. Therefore, case laws are written broadly enough to be applicable to every variety of situations. In situations where an applicable law may not be clear, the courts may engage in statutory interpretation to determine the legislature's intent, and the decision is referred to as a precedent. As a footnote, common law refers to a law that has not been actually codified or passed by legislature, but nonetheless applied by the courts based on a tradition and the legal history of the United States, and even dating back to the legal system in England. Administrative law is a body of law that governs the regulations of government agencies at the federal and state levels. It refers to the regulations created by administrative agencies which are part of the executive branch and are charged with the administration of government functions. They create the legislature through enabling statutes. Agency regulations. They develop rules or regulations and publish them in the Federal Register and give the public an opportunity to comment on the proposals. After the comment period, the agency publishes the final rule that take effect no less than 30 days after the public date of notice. Agency orders. The agency has the power of compliance with federal laws in court, known as administrative law courts. Once issued by an administrative law judge, ALJ, in these cases have the effect of the law, and many of these decisions are published in the Federal Register. As regulations become more pervasive, the body of administrative law has become increasingly important. Executive orders are written statements of the President issued as a directive or instruction for the actions of the executive agencies to set policies for the executive branch to follow. An executive order has the full force and effect of a law enacted by the legislature, except where it's contradicted by a duly passed federal law. Therefore, the President can issue an executive order to bypass Congress's bureaucracy and advance policy objectives without having to go through the legislative process. The President can draw on three sources to issue an executive order. The first is the Constitution itself. The second source of authority is from the legislative branch. The third source is the President's inherent authority, which is defined in Black's Law Dictionary as a power that necessarily derives from an office, position, or status. An executive order becomes law after published in the Federal Register for 30 days. Each of these three branches has a distinct and essential role in the function of the government to ensure no single person or entity has a monopoly of power. On the left is the legislative branch. As a whole, it is charged with passing the nation's laws. Congress may pass laws, but the President has the power to veto them. Congress, in turn, may override a veto. In the center is the executive branch, which is administered by the President of the United States. The President enforces the law that the legislative branch makes. On the right is the judicial branch, which consists of United States Supreme Court and lower federal courts. Under the Supreme Court's constitutional jurisdiction, its primary function is to hear cases that challenge the constitutionality of the legislation or require interpretation of that legislation. The lower federal courts also decide cases dealing with its constitutionality of laws, as well as cases involving the laws and treaties of United States ambassadors and public ministers, disputes between two or more states, admiralty law, also known as maritime law, and bankruptcy cases. Decisions of the lower federal courts can be and are often appealed to the U.S. Supreme Court. The two chambers of Congress, the House of Representatives and the Senate, must approve all legislation, bills, and resolutions before they can be sent to the President for signature and final enactment or passed into law. Both the House and the Senate must pass an identical bill by a simple majority vote using the same process. We'll now step through the process of how a bill becomes law. Starting in the upper left corner and moving right, first, a lawmaker introduces a bill in either the Senate or the House of Representatives. It is reviewed by the appropriate committee or subcommittee. The subcommittee reviews the bill, holds hearings, and makes amendments that it deems necessary. Once the subcommittee is satisfied with the bill, it represents the new version to the full committee. dropping down to the second row and moving from right to left. If the full committee approves the bill goes to the full chamber in which it was originally introduced, the Senate or the House, for the debate and final vote. If the first chamber passes the bill is presented to the other chamber where it is reviewed in similar fashion. Both chambers must approve the bill in identical form, dropping down to the last row and moving from left to right. Once approved by both chambers, the bill is presented to the President for signature. Once signed, the bill becomes law and is effective as the legislature has prescribed. Now, at the previous step, the President can also refuse to sign the bill, an action known as a veto. So this will jump to the step to the right of the bill becomes law. When this happens, it prevents the bill from becoming a law, although vetoes can often be overridden by a supermajority of votes by the legislature. Under the federal system, a 2/3 majority of both houses of Congress is required to override a presidential veto. Still, another option is the federal government's provision while the House legislature is still in session and the President does not sign the bill within a certain number of days, the bill will automatically become a law. Successful businesses increasingly understand the need to monitor and participate in the legislative and regulatory process since policy decisions can greatly affect the bottom line. Not only is it important to be aware of developments and participate, but actions necessary to affect change. Laws are actions passed by Congress and state legislatures. Regulations reflect how laws will be implemented and often have the force of law. Regulatory agencies may issue guidelines that interpret how these laws will be enforced. Lobbying is a form of advocacy with the intent of influencing legislators and officials, whether through other legislators, constituents, or organized group. The intent is to convince lawmakers to vote in a way that will benefit your business. HR professionals are expected to actively participate in the transformation of state and federal laws. The legislative process. HR managers need to understand the relationship between laws, agencies, regulations, and court decisions. Proposed legislation. Know what is happening in the legislative process. Informing legislators. Legislators are generally interested in information that comes from credible and informed sources. Protesting laws and agency regulations. When laws or agency regulations create unfair or intolerable conditions, help to oppose them through some form of active or passive resistance.